Hey guys, welcome back. Thanks for joining me over here in Boontown. Yes, I saw Michelle called it Boontown too. Um, I inhaled a sandwich while we were waiting. All right. Let me click the play button because I paused it just for a quick second. They are getting their camera ready. Oh, there she is. Mm-mm-mm. Let me rewind it back because I want to see her, like all of it. I want to see her come in and all that. Hey, everybody. Hello. Hi, hi, hi. Hi, 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 hi. There she is. All right. Welcome back, QB. Thank you, ma'am. And Michelle, hello. Spins says chaos has arrived. Michelle, P. Lola. Mm-mm-mm. You're cute, P. Lola. She said, when you called me out this morning, I thought A, I was going to the principal's office, B, I was voted off the island, or C, you were locking the door and not giving me the passcode. That's cute. Trial TV Live is 8 away from 1,600. Wow. If you all don't mind, can you go give them a subby if you haven't already? We so appreciate them letting us use their stream. Yes, we do. And make sure that you guys are following over there. That's amazing. They're growing, growing, growing. Radiomi says, oh, okay, I'm all packed up and ready to go to Boontown. Welcome back to this stream, Radiomi. Am I saying your name right? Please tell me. I know I asked you that the other day, but welcome back, Sherry. Thanks for coming. Hey, Billy. Pilola, I'm not sure. Are these part of her defense? I thought the other lawyers that she had were men. Unless these are like assistants or something. I don't know. Hold on, I have to sneeze. This is not good. I feel a sneeze coming on, but then it went away. Gail finished her dishes just in time. Paralegals, maybe. Hey, Miss King, welcome back. And Patricia. P. Lola says I subbed in live. Oh, I subbed and I've super chatted them. They are so cute. They are cute. I am Patricia past the 666. Yes. Right, P. Lola? She says it's throwing me off. Boone is not a girl's girl, right? Mm-mm. They're her pets, says Ween Baby. Oh, it's my spouse's name and my nicknames together. Her part was Rady, like lady, and mine is Omi, so it's Radiomi. Okay, Radiomi. Cute. Hold on a second, you guys. I'm having major Ami. So radiami. Lord, I'm the worst. Yes, radiami. I I can't promise that I'll get it right in 5 minutes, okay? But I'll try my hardest. I have to mute my camera and turn or mute my mic and turn my camera off because I just had a sandwich and you guys, it's floss pick time. I'll be right back. I'm so sorry. Okay, I'm back. Sorry. I know you guys don't want to see me pick my teeth. So I had to cover my camera up. Radiomi says she passed from MS after 30 years together, but I kept the name for us. Oh, that's sweet. And I'm sorry about that. Hey, Trial TV Live. The main feed is having major issues. This is not us, crime. Lord. Here comes Margaret screaming, Myers. Okay. Jesus, Jesus. Oof. Oh, it sounds like a CB radio, you guys. Oh my God. My ears, my eats. Okay, hold on. Let me go back to Trial TV Live. They said be prepared for the sound. Yeah, I didn't. Um, I was behind in the chat. I'm sorry. It comes back though. Okay, good deal. Good deal. Good deal. Thanks for letting us know too.
Hearing from Ms. Boone, ma'am, if you could, please raise your right hand. Madam Clerk's going to go ahead and swear you in. Okay. I believe that the first thing that was filed in this case, just as a matter of time, was the state's motion to, the defendant's motion for statement of particulars that was filed on September 2. I've reviewed that. Mr. Owens, you may proceed, sir.
Judge, do you want me at the podium?
However you feel most comfortable, sir, but because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed
Ween baby, I'm so sorry. I'm so sorry.
on behalf of Sarah Boone this motion for statement of particulars And in my motion, I quoted the language in the information that she was charged with. And the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did kill George Torres. Judge, that's about as bare bones of an information as you can file in a case. I know anytime there is a weapon used, it's usually shot
Hey,
with
Brenda.
a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres. This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase, asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torres? And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, Pajon, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day.
Can't make this stuff up,
leaving her,
Michelle.
confused as to what we are talking about. There is no exposure to double jeopardy. There's no element of surprise. The state of Florida has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced, and they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars.
Okay, sorry. Got to stop for just a quick second because, Michelle was saying that her AirPod blew out when that thing happened a while ago when the stream started. And QB said she got a visual of it because QB is a very visual person. So now QB can't quit giggling. And then I said my visual of it, because AirPods are white, usually, typically. I mean, like my AirPods are white. And I'm like, I can just see that thing blowing up, blowing out. And I said, to me, in my mind, it would resemble a piece of buttered popcorn because popcorn is white, but then you have the buttered part, which would be the earwax. Sorry, I know that was gross. QB's about to just vomit everywhere. But Michelle said in the chat, I'm literally eating popcorn. And I'm like, no, you're not. She's like, I'll send you a picture. So she sends QB the picture. You guys, look, I ain't even kidding. I can't even. Look at this. Hold on. Hold on. Here we go. Look. I can't. That looks delicious, though. Can I? Now I want freaking popcorn. Do I have any popcorn? I don't think I have any popcorn. I would love some. Oh, my God. I want popcorn now. Okay. Back to our regularly scheduled programming. But I swear to God, I had no idea she was eating popcorn when I said it. Enjoy your all's earwax buttered popcorn. Love you. Mean it. Let's go back over here. Oops, I hit the wrong button again. Hold on. Share. This one right here. Okay. Thank you for our TED Talk. Thank you for joining our TED Talk.
There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day, there are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue.
Chaloon,
about
hey,
whether to
girly.
require
It's good to
the
see
state
you.
attorney's office to give more particulars about the offense. And this is somewhat of a unique case, and the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death, and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed, whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I
What's
understand,
missing?
and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law, based on the unique set of facts, that a court feels compelled, yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts, that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives 2 explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did that constitute. Is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776. and relying on State versus Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank you.
Moving now to, give me a moment, and I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes. Thank you, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before any interrogation. Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office, and we did make a request to the Orange County Sheriff's Department back on September the 10th, and the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020, and the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room, and I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end. So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, September the 10th, now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the 2 detectives, the 2 homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily
Hey,
because
totally
it's
not a cop.
immaterial, and then secondarily because it's on them. She's been
Good to
aware of
see
these
you.
statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Side note, totally not a cop. This morning when I was packing my kiddos' lunch for school, I was throwing a nutty bar. I think they're called Nutty Buddies now from Little Debbie snack cakes. But I was packing her a nutty bar in her lunch bag. And I said to myself, totally not a cop was wrong. These are not cheap. And they are not just for kids. I mean, I know, I'm still offended too, QB. I'm kidding. I'm totally not offended. But the nutty bars are my favorite, right? Anyway, so they ain't just for kids, and they sure as heck ain't cheap, at least not anymore. They used to be, but not anymore. We spend a daggone fortune on Debbie cakes. Well, even the cheap ones, if we buy the generics, they're still doggone, man. Costs $1 million just to go through the bread aisle and the Debbie cake aisle. Anyway, all right.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct, and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here, because I haven't watched the video. I'm not asking you to play
I
it,
probably should have.
but I need a little bit more context as to these statements, because I have unfortunately no frame of reference.
But she says that, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, is this where I go to get the phone? He said, no, we got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them, And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk to you about that. 2 times she said, we must, I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And
Again.
she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that
Again.
responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone, I believe it was the female detective and the male detective, and she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and
you
the
tell
lead
me,
detective says,
P-Lola,
"We've
how
got to
quick
talk
can
to
a
you
kid
about this
tear through a
autopsy."
box of those?
Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said, protocol? Because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda, judge, she made a mistake on it. I don't know if it's an honest mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video. There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court.
Oh,
I'd
Jesus,
like to get their
Jesus,
policy
Jesus.
just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they...
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling...
That's in the probable cause statement.
Okay, that it was read verbatim. Okay,
Yes,
excuse me.
formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is, it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think
that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and...
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so, along
That doesn't
with
answer
her
my
other 2
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper, that they're used to coerce somebody to talk. And I understand the detective They had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce
Somebody,
or influence
please.
her.
Somebody, please tell me that he ain't got a leg to stand on here. I mean, please tell me he ain't even got a pinky toe to stand on here. Please. I mean, I don't know the law or whatever well enough, period, at all to know if he has a pinky toenail, a pinky anything, no, to stand on. Does he?
To speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those two statements preliminarily that I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Just, the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in the court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in, if those statements are admissible, and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken is what it is, I think state versus right is the guiding light for the court here, 803 Southern 2nd, 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright. Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing, and we did confirm that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to cost.
I don't know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
if I
have to
got it
ask
yet.
Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing.
Margaret,
Can
did
I-
you send
can I
that?
see my copy?
Where you at,
And Mr.
Margaret?
Jay, have you seen that, sir?
Did you forward that to the judge, Margaret?
Understood, thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
filed this afternoon.
That's what happens when you get in a
this
hurry,
morning.
Okay.
counselor.
All right, what is the other motion related to cost, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's nunc-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, August, I believe, August the 30th.
That's correct.
And then I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County, and she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her, and she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to be in work on the case. And then the last,
When was that, you're asking nunc-pro-tunc to win on that? Also to the August 30th date?
Margaret.
Of your
Yes.
appearance?
if possible,
Margaret?
yes. That's when I officially got on the case.
Oh, I'm
Now,
sorry,
as to
Margaret.
the third motion for cost, I don't have a copy.
I was just making a joke, Margaret, because the lawyer said that he didn't know if an amended something or other was sent to the judge because he needs to ask Margaret if she forwarded it. So we need to know, did you forward that to the judge? Because he said Margaret forwarded it.
Copy of that, unfortunately.
Can I approach?
Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I
Your
think we
pink
had on
tutu is in the
September
mail,
3rd.
Margaret.
He's a clinical psychologist. If you'll recall, I'd mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
Do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Berkland. And it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion, under 3220.
Those are the best. I love those.
Trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. That's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says
Sure.
before
And
I make a
I'm not-
decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Central?
Is that in person or is that virtual?
I believe it.
Okay.
The state's flying in, and I'm going to be there, Judge. That's the county over from me, Santa Rosa County, so about an hour drive for me, so I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick, Judge.
Sure.
Give me a minute.
Yeah, you're good.
If I could, Brenda, I would totally be there. I'd love to see this trial.
While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones.
Were the-
It had to be filed prior to my motions for appointment of these experts.
Give me a second.
I got some Little Debbie pumpkin delights in the cabinet right now.
Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon,
Oh, the
was
trial's
filed
gonna be in
yesterday. The
Orange
amended
County,
motions
Brenda.
regarding Dr. Berglund, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted non-protunct to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon, and maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken, and I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any.
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get another imaging if they are not satisfied with the imaging that has been provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm going to do my best. We got about 18 days.
I'll cite to the parties for their own benefit, there were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert, and there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance.
Be right back, guys. I got to go do something real quick, but I'll be right back.
And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I had filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed, after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert, and we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing, I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge, realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on phone. So we're diligently trying, number one, to review all the discovery, which still has not been done, at the same time trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties. that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was a lot, quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client. In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape, please look at my phone, please look at the videotape, please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered woman syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we have filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse, and again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14, says the defendant's investigation of evidence to support the defense of battered women's syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them, and when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic, and he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense, it is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in the defendant's opening statement but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
That's not to be decided today. That's not, Wagner, whether it's an accident or whether it's battered spouse and there was self-defense, that's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow, Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed.
I like how he's trying to tell the judge how things are going to go.
Ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered, even
It's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically
specifically?
says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located.
Good call, QB. You guys look up in the top right-hand corner of the screen. That's the, it was horrific face.
Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused, and that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase? Was that the overt act that caused the death?
But all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at bar?
I assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase, and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Yeah, because that's what happened. I'm confused. I mean, is he trying to say that it's self-defense because he's like, oh, I accidentally tripped and fell into this suitcase, and she's like, oh, well, now while I have the chance before he beats me up, I'm going to zip him up real quick in it, and then that wore me out, so now I need to go upstairs and fall asleep or pass out or whatever you want to call it, and it was self-defense. She didn't do CPR either, Michelle. I ain't buying that. I don't even think she did it when she was on the phone with 911. That's just my opinion.
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I
of
don't
particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said, on the issue of imminent threat, it is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the
Y'all, they have got together and they have cooked up some cockamamie story about what took place 2 to 3 minutes before he got zipped up into that suitcase. I'm not gonna lie, I still like this attorney. He's standing there fighting for his client. And this judge and him, the back and forth is pretty, yeah. I'm not mad at it.
defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
Judge, open your ears. He said that 100 times.
Word self-defense never came out of your mouth.
Judge,
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
Judge, for
Is it just me, or did he not say self-defense a while ago? No, Susan, I mean, they've come up with some story. The way he just said that, because you don't know, she has to testify to what? She has to testify to what happened the 2 or 3 minutes before he got zipped up in that suitcase. So, in my mind, that's telling me he's wanting her to testify. I can't believe she wouldn't get up there on the stand and testify. But they've come up with some cockamamie story, I'm telling you, to say self-defense. And he's been saying self-defense. He did say battered spouse, but he said that the way that the state was going to come at it was going to be, this, that, and the other. And he's like, he's said self-defense a few times. He was coming at her and he tripped, fell in the suitcase. Yeah, right. She saw the opportunity to save her life. I mean, I can just hear it now.
the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Judge?
I can, but
Jesus, this audio. Oh, Lord. Let me mute it. Or turn it way down. Way down. You guys,
but I have some concerns getting reverb to you.
ooh.
I am trying to talk you now. Are you able to hear me better?
Oh.
I am, but it's my that we're hearing back again through your microphone.
Turn that volume down.
All right, this may work. Mr. Henderson, we'll give this a shot, sir.
That audio
You can
made
go
me
ahead.
plumb sick at my stomach.
Can you hear me now?
I can, sir.
Is that better?
Yes, sir, it is.
Yes.
God.
Yes, Judge, I'd like to respond. But first, where I want to start just the self-defense justified the use of deadly force, justified the use of non-deadly force. Those are defenses that do not require a notice at all. A defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear, an indication or evidence. It's just a scintilla of evidence, is what the cases say, to get the instruction. There's no notice requirement in self-defense at all. Now, battered wife syndrome is not a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury instruction and what it explains is when you get to the point when you're starting to talk about imminent danger.
This guy is really into what he's saying, and I wish I could understand a word that's coming out of his mouth. I did hear him say that battered spouse syndrome itself is not a defense.
And that because of this syndrome, they would perceive an imminent danger different than someone else. Because what the self-defense instruction requires is that the jury place themselves in the position of the defendant. In those circumstances, at that point, battered spouse was to help explain those circumstances. So the first instruction that you have to get before you can even start talking about battered spouse is this. You have to get the self-defense instruction. So, and that will be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense. This is self-defense. There's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of the self-defense part of it, then
No idea, Michelle. It looks ridiculous with him looking that way or that way, whichever way you guys are looking, whichever way it is on the screen. But I mean, he might be reading his notes. I don't know, but it's almost like I don't know. Yeah, this is a lot.
the court can give that instruction if they find it sufficient. The testimony can give that instruction as to self-defense. When a battered spouse comes in and as it goes into a series, you have to have self-defense or some type of evidence of abuse before you can get into the battered spouse. And this is how it should work. There could be the testimony of Ms. Boone. There could be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries on Ms. Boone. There could be testimony from others, neighbors, or other people who observed injuries or certain things to Ms. Boone. But once you get to the point where you significantly or sufficiently apply that there is a battery or domestic violence situation that is ongoing, then, and not before that point, can the expert come in and testify? So the stopgaps on this that are built into our system. First, there has to be some accountability or some evidence of self-defense. Secondly, there has to be some evidence that will support the expert's testimony to become relevant at that time. Once the expert's testimony becomes relevant, then the expert can testify about these are the symptoms that I observed, this is what I watched, this is where it came from, this was interviews, this was reviewing other type of data and other types of things and preparing the to that point, Judge, when you get to that point, then it doesn't become a judicial act at that point in time. What it becomes a jury question. And it's up to the jury to decide. And what it does, and it doesn't say that battered spouse is a defense. What it will talk about in the jury instruction is this is something in the back and willing vote. Under these circumstances, if you find it credible, that you can consider. And that's what it does. So we at the beginning when we start talking about motions to strike, because if I think the station is Wagner.
Did you see that closed caption that said, please subscribe? Watch. Look. Please subscribe because if. Sorry. Why does it say that? I don't know.
Because if I think the station is Wagner, there wasn't any testimony there. Wagner's testimony was excellent, and I really put it. No one really needed the ruling of that. That was the testimony. In this case, we do not have testimony. What we have is to say, in this case, saying the discovery in this case don't fit. But that's not all. These rules have to be made better. On the testimony of critical report, either testimony itself, critical evidence.
Mr. Henderson, we're having a difficult time understanding you, sir.
I'm sorry, Judge.
You're going to let him go through all that and just now tell him that they're having a hard time hearing you? Hi, Lista. Cool name. Lista says his audio is making me miss the Idaho potato.
Is that better?
No.
Maybe. Madam Court Reporter and I were having a little bit of difficulty hearing you at the end. You seem to be projecting away from where your microphone is.
Okay.
No good. No bueno.
Madam Court Reporter. We will do our best, sir. Keep going.
Jesus.
Yeah. So,
I can't.
to bring a little court landing, Judge, is simply this. And to the court, here's the evidence that permitted at trial. The court cannot make certain decisions. The court can't make
There's your potato right there on the wall. It's spiral cut and everything. I mean, right there it is. They've took the potato, they've cut it all up into a big giant spiral and slung it on the wall. That's why we can't hear a dang thing.
and to the evidence at trial. At that point in time, the court has to make a decision if, after evidence, if the expert's testimony is even relevant. So if there isn't any testimony to prove the relevancy or to show the relevancy of the expert's testimony, then that expert can't come up and talk about battered spouse. Now, if you don't get the expert to talk about battered spouse and render an expert opinion, battered spouse is out the window. So then you're just on self-defense at that time. But that argument.
Blah, 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 battered spouse, blah, 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 and then blah, 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 blah. That's all I can hear.
And that decision can only be made after the evidence is put in at trial. And that's all I have, Judge. Thanks.
Oh, thank you, Jesus. Thank you. Thank you.
It sounds like we're largely on the same page.
And that's all I have to say about that.
The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's an Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page, that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position, to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery, and what left the state at a lapse in understanding this defense in particular, was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog, and then like everybody else, we were playing hide and seek, and he got into the suitcase, and I accidentally went to sleep. And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself. Mr. Henderson, you're still muted, sir.
I'm sorry. Can you hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
Yes, Judge. The state is going to have the opportunity to depose the expert, Ms. Harper, who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Mr. Owens has told you, this is an ongoing process, and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time filed September 17th. Mr. Jay, have you had the opportunity to review that?
Right, Lisa?
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may
Court
proceed,
reporter
sir.
quit.
And I do have about 2 or 3 other issues that we need to address, but yeah, I've asked for some time. I think there was an order, I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates, and I think that's a typo on paragraph 3. I said August 17, that should be September 17. On paragraph 3, Judge, of my defendant's motion for enlargement of time.
That says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong thing?
I'm sorry, I was looking at the wrong one. If you look at the second page.
Yes, sir.
Paragraph 7.
Yes.
That should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move, so we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owen's trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy has attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment. Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So,
Just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting you all, full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back, either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday. And we'll start whittling it down. And I can turn over, when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take us to get a jury.
I did not anticipate, I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m., I got 50 people teed up for 1:30, and that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous. But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago. Trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. Although we're not contesting it beyond objecting, we do object to any rate in excess of the rates established by law, but we acknowledge for this type of expert that it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files, so far the defense has incurred, this is prior to Mr. Owens' involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert that's being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name, I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed rates for the circuit, we don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense, but that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
The motion reflects the rate as $200 per hour. Is that in excess of the JACS rate?
Your Honor, it's in excess of the rates for the circuit. Those were the rates that were adopted back in by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, you know, that the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website, and I'm pulling them up right now because for the Ninth Circuit, the rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further?
Nothing on this.
Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going to be nunc pro tunc, because I've received nothing from you, Mr. Owens, that he's done any work yet.
That's correct.
Okay, so this will be effective as of today, the 17th of February.
September?
Yeah, is that not what I just said? I'm sorry if I did, said a different date. I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
This relates to the investigator, Billy Lane, who's working with the defense, and his potential costs up to the trial.
Are these being hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes. So do I need to
So,
file something?
Get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the total amount of clothing that they had that would fit Ms. Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free rein and was going to have the shock device on her lower leg. I would ask that you can email Ms. Click. You can find her information on the Florida Bar webpage, and ask her if the public defender would assist you in provided clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. One is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you could get it to her.
Okay.
So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, she would like for us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay. I believe that's all I have, Judge.
Okay, all right. Anything else, State, we need to address?
No, Your Honor.
All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right, thank you all very much. We're off the record.
Sorry, husband walked in literally from work and I was just showing him the baby's new shoes. The baby's new shoes. Look for the wedding. Aren't they so pretty? They're so pretty. Can't wait for her to go home. Try them on and see them. I missed what y'all are talking about just the last couple of minutes. I missed it. Oh, hold on. He's showing me his shirt for the wedding. Oh, that's pretty. It'll match the shirt I'm going to wear. Yay! We're going to be so pretty. She wants hair and makeup. Are you serious? Are you serious? Okay, I got to rewind it and listen to that. You're lying to me right now. You're lying, right? Tell me you guys are lying. You're lying, right? Seriously? Oh my God. Okay, I gotta. Oh my God.
At the September 26th case management conference, we can do it then?
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do that.
give these
Did I
back to you, sir.
rewind it far
Judge,
enough back?
The other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here.
Okay, I
that we've
heard
gotta
this
be in front
part.
of the
I remember this
microphone.
part.
Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes. So do I need to
So
file something?
get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Miss Click. You can find her information on the Florida Bar webpage, and ask her if the public defender would assist you in provided clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. One is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you could get it to her.
Okay.
So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, we would like, she would like for us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay. I believe that's all I have, Judge.
Okay, all right. Anything else, State, we need to address? All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right, thank you all very much. We're off the record.
I have never heard of that before in my life. You know what, Sarah Boone? You need to take a page out of Lori Vallow's book, ma'am. Use some of your commissary and get you some cherry Kool-Aid. I mean, if she came in with a different hairstyle, nobody would even know who she is. And what are you going to do with that? Well, I mean, you can She's going to want it curled, or does she want like extensions or what? She acts like she's going on like the Tonight Show or something and needs hair and makeup. I ain't neither. QB ain't never in my life. Her fans want to see her in all of her glory. Oh my God. I can't with this one. Yeah, she's wanting an extension. Kel, hey Kel. Good to see you, babe. Shave it off and get a face tattoo. You are not a superstar. Superstar. She wears me out. Well, here's the thing, Ween Baby. Yeah, it could be fixed super cute. I mean, we see all kinds of pretty women with super duper short hair. I mean, I love some of those are very, you know, you can do a lot of things with it. But what I don't understand is how is any of that going to make you look more presentable? I don't get it. Right, Spins? Mm-mm-mm. I don't know. I don't know. All right. Now, hold on a minute. Hold on a minute. We have to go back. She wants the VO5 and the bedhead products. She wants the not she wants the Nacho Mama hair care products, right? That good dry shampoo and volumizing spray, and she's wanting hair extension and probably get her eyelashes done and get her brows all microbladed and just get you some cherry Kool-Aid. Man. No, don't get me wrong. I'm not going to say that's mean. If you can have access to some makeup, fine. If you can have access to, you know, put you some pretty makeup on, go for it. If you have access to something to do your hair up, do it. But calling for like a hairdresser or a makeup person, no. Mm-mm. Even that lawyer said she didn't excel with that haircut. He's basically like, and the lawyer's like, am I going to have to file a motion for that? And the judge is like, yeah. It's a no, Sarah. It's a no. All right. What am I doing? I need to figure out what I'm doing. I need to get over here to this other StreamYard and go into the after lunch for Carly Gregg. I need to edit it real quick so I can change the time to, let me change it to 4 p.m. Make it public. Save. And then we're going to go into view on YouTube. And then let me get you guys the link so you'll have it to run on over to watch part 2 of Carly Gregg trial. She wants a spit shine. Oh my God. I don't know, Margaret. My ears are numb still. Maybe her cellmate can help her. Right, P. Lola, she's had that haircut for 10 years. Now she wants to look feminine. She's wanting her lips plumped. I don't know. Does jail even have commissary? Well, I mean, yeah. Yeah, they can get commissary, right? I mean, I've known people in jail that gets commissary. Here's okay, Carly, Greg, trial part 2. Here's the link for it in the chat. You guys can run over there and hang out. We'll be starting in about. I put it on 4 o'clock, but I'm wanting to wait until kiddo gets home and show her these shoes, see if they fit her, and then I'll be jumping on. So she'll be home any second. So make sure that you guys like and subscribe before you jump out of here and click that link to go over to Carly Gregg trial that we're going to go over there to here in a few minutes. So she'll come in with long nails and a push-up bra. Yeah, she's going to try her pretty shoes on. Yes, they have commissary and your family can put money. That's what we did, yeah. I mean, yeah. All right. I'm going to go and I'll see you guys back in just a moment. Hashtag replay in the comments down below if you're watching on the replay. Love you guys. Sarah Boone, you, ma'am, are no celebrity. I can't think of a celebrity off the top of my head to like. No. See you guys over there in a little bit. Bye.